Hello, my name's Chris and welcome to this an NMI webinar in partnership with NMI member EIP. Today we're going to hear from 3 IP experts about the role that IP takes in developing partnerships with other organizations. We'll hear about the key issues that arise when collaborating with suppliers, customers and universities, as well as discussing basic IP strategy for semiconductor and electronic businesses. We'll hear about IP strategy and how it should be developed when collaboration is a key part of your business plan. I also have alongside me today NMI Network Director Adam Wood, and today's speakers are as follows. Introducing first, Mark Lubbock. Mark is a partner and head of commercial at EIP. Mark is an experienced commercial IP and data protection lawyer who has advised many clients in the semiconductor and electronics sectors on a wide variety of commercial arrangements, including patent and know-how licenses, IP assignments, manufacturing agreements, joint development, and R&D and collaboration agreements. We'll also hear from Anne McAleer, who is head of IP at Paragraph, the UK's leading developer for graphene-based technology. Anne has worked in development, management, and licensing of IP in the semiconductor and mobile comms industry for more than 20 years and has experience of working in both startups and large corporations. As head of IP at Paragraph, she's responsible for the definition and implementation of Paragraph's strategy to maximize the value of its IP in graphene electronics. But first up today, we'll have Andrew Thompson. Andy is a partner and head of Amplify at EIP. He is a patent attorney with a background in semiconductors and electronics and has worked for global semiconductor companies as well as UK-based startups and scale-ups. He's an expert in IP strategy and is experienced in helping companies develop an approach to IP which supports their business objectives. If you have any questions or comments for any of today's speakers, please put them in Zoom chat and we'll raise those during the Q&A section of the broadcast towards the end. So like I said, first up today is Andy of EIP. The floor is yours, my friend.
Great. Thank you very much, Chris. So just give me 1 minute to get my slides up on screen. Okay, is that all looking okay?
That's looking great, Andy.
Great. Okay, well, yeah, it's very good to be here. Thank you, Chris, and thank you to the NMI for hosting the webinar today. We're delighted to be able to talk to you about the role of IP in developing partnerships, and I hope you get something out of the next 45 minutes or so. So first up, I'm just going to give you a quick overview of what we're going to cover before we jump straight into the meat of it. So I'm going to begin with a bit of an introduction, talking a bit about what we mean by partnerships and why they're important to this sector. I'll also cover some of the basics of IP strategy and why IP is important when collaborating with third parties. We'll then hear from Anne, who's going to give us her experiences from the front line, as it were, as the head of IP at Paragraph. And finally, we'll get some practical tips on contracts and agreements to help secure your IP when entering into partnership from EIP's very own Mark Lubbock. And then hopefully we'll have some time for some questions at the end. Okay, so to kick us off, what do we mean by partnerships? Well, as a technology business, you'll have many reasons to work with organizations outside of your own in order to meet your business objectives. For example, this might involve collaborating with customers. It might involve working with suppliers to ensure that the materials and equipment you need are fit for your requirements. Alternatively, it might mean working with R&D outfits or even universities. Partnerships play a particularly important role in the semiconductor and electronics space, especially in the startup and scale-up end of the sector. There are very few companies that build everything in-house and sell, as it were, off-the-shelf products. Collaborations typically required right across the supply chain. And as we all know, the semiconductor supply chain spans everything from materials, design, equipment, all the way up to the OEMs who build the systems that incorporate your products. These sorts of collaborations and partnerships are often highly publicized. Hopefully you can see on screen just now a few examples of partnerships that have hit the headlines recently. Many of these were fueled by disruption during COVID and the recognition of the need to make supply chains more resilient. For example, numerous partnerships have sprung up between the automotive sector and the semiconductor sector. So this is all well and good, but if collaborations are not handled properly, disputes can arise. The one that we see on screen at the moment is one high-profile example of this, which some of you may be aware of, the dispute between Global Foundries, the US fab, and IBM. They collaborated on chip-making technologies way back in 2014. However, after the relationship ended, and as you may know, Global Foundries bought IBM's semiconductor manufacturing business, the two companies entered into years of disputes over IP and trade secrets, much of which is ongoing and some of which has only been recently resolved. Conversely, when it's done right, collaborations can be immensely successful and generate significant value. So one example is IMEC, the Belgian Semiconductor Research Institute. They successfully manage projects and collaborations with most of the major players in the industry. And it does all of this while protecting everyone's IP effectively. And of course, in the UK, we have our very own Catapult program, which similarly manages collaborations effectively to generate value and boost the UK's own capabilities. So how does IP come into all of this? Well, you might typically think about IP as a means of protection. You invest in R&D, you take steps to protect that investment with patents, trade secrets, and other forms of intellectual property. Essentially, you put up a wall around your castle to keep others out and to provide you with a competitive advantage. All of this is true and holds. It's certainly one of the primary goals of an IP strategy. However, it can also be important in ensuring that collaborations are successful. Firstly, in any collaboration, it's important to be clear about who owns what before you start working together. Because IP is typically documented, it can provide a really good way of delineating the ideas that parties bring to the table. Secondly, it can build trust. Knowing the other party has a healthy attitude to IP and a respect for their own IP increases the chance that they'll have a similar attitude to the IP generated as part of a collaboration. Finally, you have to have a way of capturing the value that's generated during any collaboration and who owns it. And IP can be an effective way of doing this. And this is where the importance of contracts, which define who brings what to the table, and how IP is generated, how IP that's generated during the collaboration is handled. So in summary then, IP effectively provides a very good way to regulate the sharing of ideas. Okay, so let's talk briefly then about the role of IP strategy in developing partnerships. The castle that you can see on the screen represents your business, and the various arrows show how IP can move in and out of those castle walls. The brain at the top represents the people who come into your business. This is your main source of what we're calling intellectual capital. It's expensive and it's very hard to come by. Once that intellectual capital enters your business, you really need a clear plan to ensure you protect it and it shouldn't be exposed outside without a very clear strategy. The primary true form of protection is, of course, to keep all of your ideas confidential, or even protect them with trade secrets, as trade secrets. However, the problem with that is that as a business, you do need to disclose what you're doing to the outside world, meaning you can't necessarily keep everything secret. So, for example, ultimately, you'll most likely be selling products. This inevitably leads to your IP being discoverable by customers and third parties. To deal with this, you might consider filing patents, and these can be very useful to protect aspects of your products which are discoverable once they're on the market. You'll also find lots of IP leaks out of your business, goes down the drain, as it were. This might be from people leaving, from poor contracts, occasionally accidental disclosures, often by key people within the business, or even by theft in some cases. And then beyond all of that, there are partnerships, which we're talking about today. These are interesting because the flow of IP is effectively in two directions. You've got to let it out to the business to make a collaboration work, but hopefully what you get back is even greater to you and your, the partners that you're collaborating with, and it ultimately boosts the value of your business. So management of all of this is called IP strategy. It's very important to any technology business, but it's especially important where collaborations are central to your business plan. Fundamentally, an IP strategy is all about maximizing the value of ideas to your company. This might be about providing competitive advantage. It might be about giving credibility to your technology, or it might be about helping secure the next round of investment. Typically, however, it's a mix of all of these things. For companies involved in collaborations, there are specific considerations, however. A careful assessment always needs to be made about what you share with partners and what this means for getting the balance right between patents, trade secrets, and other forms of intellectual property. Furthermore, it's always critical to be clear about who owns what going into a collaboration and who will own the IP generated by the collaboration. Getting this right, is partly about your own IP strategy, but as Mark will come on to talk a bit more about at the end, it's also about your contracts and agreements and making sure they are fit for purpose. So you might think figuring out all of this is easy. It's often quite complicated, and the cracks typically only appear years later, and that's when disputes can arise between parties, as we saw with GlobalFoundries and IBM. So with all of that in mind, I'm now going to hand over to Anne, who's going to share some of her tales from her experiences on the front line. So Anne, over to you.
Hello there. Thanks very much for that, Andy. Yeah, as Andy said, I've over the years worked in numerous technology companies. And some of those companies I've worked for have been startups, and some of them have been very large corporations. But regardless of the size, managing collaborations in those companies has been critical to the success. And the reason for that is, as Andy was saying, when collaboration works well, value is created. And how you interpret that word value can be quite wide. That value might be a problem solved. Perhaps you're creating a new product or service that you can sell or license. You might be saving costs or saving time by working together. Next slide, please. But when the collaboration goes badly, then the value can be lost, either partially or entirely. And the project outcomes are not achieved of that fantastic project you set up with all sorts of good intentions. Trust between the parties gets lost. You might end up in dispute. And in worst case scenario, like IBM GlobalFoundries, you might end up in litigation. And litigation is going to be a huge distraction from your day-to-day business. Legal costs and damages, potentially. You could be forced to redesign your product. You could be blocked from selling your product. And certainly you could get reputational damage where your company's name's in the headlines. So to add some color to this, I'm going to talk now about two common collaboration scenarios for startups. The first I'm going to talk about is about two technical companies working together where there's an imbalance of power. One party I'm going to call David is a scale-up company, and the other party I'm going to call Goliath is a large established corporation. So there's an imbalance of power, and that imbalance of power can lead to difficulties at different stages. So during the contract negotiation stage first, often there's a pressure on David to get a deal signed. David needs revenue urgently and needs to show commercial traction to its investors. It needs to get a deal with Goliath. And Goliath usually knows this too and can take advantage of that desperation on David's part. And when you're working on a contract for an IP collaboration, it's normal to start, rather than a blank piece of paper, but for one of the parties to bring a template. And in a power imbalance scenario, it's usually Goliath's template you're starting from. And it's common that's going to have unfavorable IP terms for David. Worst case scenario, all arising IP that comes out of the project gets assigned to Goliath with few or no rights back to David. The problem is, David's business plan usually requires, for success in the future, not just working with Goliath, but maybe Goliath's direct competitors, in which case David needs to claw back some of those rights to that arising IP so it can work in other projects outside of this one. And if there's a further imbalance, sometimes if the situation is such that Goliath's actually funding the project, because it's not unreasonable to expect if Goliath's funding that they would get some preferential rights to the IP that arises in return for that. And if that's not ownership of the IP, then it's going to have to be something significant like royalty-free license or some degree of exclusivity or lead in the market. So what I'm saying is that as a consequence of a power imbalance between the parties, it's hard work to get to a situation where there's a win-win for both parties in this collaboration. You can do it, but it needs both parties to be flexible and really drill down on what they want from the collaboration, but also specifically what they need from the collaboration. And sometimes what you want and what you need are not the same thing. So once the agreement gets going, the agreement's signed, the project starts, then this power imbalance can still lead to problems. So I'm going to tell you a war story now about what happens if you don't actively manage IP on the ground during the project. So in this situation, David and Goliath were collaborating in a joint development project, and they were working on new technology and sharing information. When the project was underway, unbeknown to David, Goliath filed patents with claims that read on confidential information belonging to David. David only found out 18 months after the patents were filed, when they were published. And it was pretty easy for David to spot that its confidential IP was in those patents, because Goliath had helpfully cut and paste from the PowerPoint presentations belonging to David and put those in as the diagrams in the patents. So David protested. Goliath said the patented inventions were its own, that David had no rights to the patents, and there was no need to change the names on the patents to inventors from David. David sought legal advice, and David was advised that it had grounds to take legal action on multiple fronts against Goliath. This was a breach of confidentiality, a breach of the collaboration contract, and they also could have disputed the inventorship of the patented material at the patent office. But for David at the time, none of these were possibilities. The cost of the action and the distraction just wasn't a realistic possibility for it to take action. So it led to a huge amount of distraction from the daily business, high stakes phone calls between two CEOs, and ultimately resulted in the breakdown of that collaboration. So I'm going to bring in Mark at this point. I think there are some things that David could or should have done that might have meant that came out differently. Mark, have you got some suggestions?
Well, thanks, Anne. Yeah, I mean, it's obviously very tricky because one of the parties has got massive balancing, massive power, and you can see from the picture up on the screen that the pitch point has moved to the right, to the Goliath side. But there are probably some things that in the contract negotiations that you can think about to try and give some protection. There's the practical point, of course, about filing first. It needs to be in touch with its patent attorneys and get its filing in first. And then looking at the agreement itself, there's an advantage to agreements having detailed governance procedures and record-keeping obligations, so it's clear who shared what information when and who the inventors are, and this can support entitlement proceedings, which are somewhat cheaper than infringement proceedings, and it may be that David could afford those. There's also the practical point about restricting what information you're giving to Goliath only on an absolute need-to-know basis, and make it clear what's confidential as you go along, and try and avoid handing crown jewels over. But apart from that, it is tricky in a true collaboration. In the negotiation period as well, just a further thought is it's important for David to know what it wants to argue on the outstanding issues, to know what's important to it, and not waste time and goodwill in negotiating issues which are not in the end that important. So I mean, it's a tricky position, but there are some things that David can do. I'll hand back to you, Anne, now.
Thanks, Mark. Yeah, I think there definitely were things that could have been done better there, that could have led to a better outcome. The second situation I'm going to talk about now, which is common for both startups and scale-ups, is collaborating with universities. Working with universities is wonderful in terms of getting access to the brightest minds and cutting-edge technology. Paragraph has unique active collaborations at the moment going with universities of Glasgow, Birmingham, Cambridge, Queen Mary University, UCSD in the US, and many other universities. And we definitely benefit hugely from working with universities, and I like to think they benefit from working with an industrial partner too. So in setting up and running collaborations with universities, I've had to learn a couple of things. And I've learned that there are some different collaborations that you have to consider compared to when you're collaborating with commercial companies. Fundamentally, universities have charitable status. They are funded by the taxpayer, and they are subject to regulations that can sometimes challenge what a commercial company might think it wants. For example, confidentiality. So when creating new IP, a commercial company intuitively wants to keep all details of a new product, for example, confidential until it's ready to launch. However, universities must publish and must teach, and academics are not really keen to sign up to confidentiality clause unless the clauses are very, very focused and/or short-term. Another important point is that universities require to be paid for the IP that they generate in a collaboration. If it was two companies collaborating, sometimes you don't have to have that exchange of money. There could be some cross license, but the university doesn't need a license back. You can only offer monetary reward to the university in exchange for the IP, and that can be a challenge for cash-strapped startups. The other thing about the work that you're doing with universities, it's usually very early stage technology where the market potential is extremely uncertain, and there's a long way to go, a lot of work still to do to productize and commercialize that IP. So having just said that you need to pay the university for the IP, then how do you work out what's reasonable to pay? Often the solution to that is to come up with an agreement to agree. So you'll decide later what's fair and reasonable to pay for that IP. But that's not terribly great for deterministic business planning for the commercial company. I mentioned earlier when I was talking about the David Goliath scenario about the use of template agreements. And my experience of working with universities is it's usually best to start with the university's template. But I've found often there's an expectation that if IP is going to be jointly developed in the project, the university expects that IP to be jointly owned. And generally, most of the time, jointly owned IP is not a good idea for commercial companies that operate in global markets. And from my point of view, joint IP is also a real nightmare to administer in a busy IP department. A further consideration that comes into play when working with universities is the risk of IP contamination. I think it's fair to say that in any collaboration, whether it's with a university or a commercial company or whatever, there's always a risk that the project outcome somehow incorporates IP in it that belongs to a third party that you don't have the rights to use. However, this is particularly a consideration with university. It's very common for academics to move from institution to institution to institution and carry on research in each place. But the chain of title rights to that IP doesn't necessarily come with that academic. Another thing is that illustrious academics are in huge demand, and they're often working on multiple things at the same time. So at the same time they're working with you, they could be working on industrial collaborations with many other partners. They have students in their labs that are sponsored. So you have to think about collaboration, sometimes that potential of contamination coming into the IP that's developed, or maybe some of it leaking out too. So you keep these considerations in your head. Next slide, please. So bringing my section to a close now, we've just talked about two common scenarios of collaboration, the David and Goliath and the university collaboration. And there's significant value to be had in those collaborations when that works well. To make it do well, at the contract stage, you need to be very carefully considering what the scope of the collaboration is, what the inputs and outputs are, what background IP is each party bringing, what IP arises from that project, who invents that, is it done jointly or solely, and how do the contributions of the different parties interface, and how are you going to protect the arising IP? To reach agreement, it can be difficult, but think about what each party wants and what they actually need, and try and be flexible. Don't be too rigid. I have a problem with that sometimes. Try and keep your eye on the prize, the value to be had in this collaboration. And finally, as the project proceeds, as what Mark was saying there as well about the David and Goliath scenario, you need active management of IP on the ground. You can't just sign the agreement and forget all about it. So that would be my practical tips. Now I'm going to hand back to Mark, who's going to give some more expert advice about how to deal with collaborations. Mark?
Thanks, Anne. That's an absolutely brilliant run through of a lot of the critical issues involved, and I think that I'll be picking up on quite a few of those points in the course of the next 10 minutes or so, while I explore some of the key issues that can arise from the contractual perspective in the startup journey. So, I mean, in this 10-minute session, I've divided up the startup journey into 4 stages: innovation, development, investment, exploitation. And I'll run through some of the contractual issues that crop up in each of those. In the time available, I'll just have to focus on, 1 or 2 each. Before I start, just a request for startups and spin-ups, just to get the basic presentation of their the way they present themselves, and the basics right. So there's a requirement under the Companies Act that any corporate documents have to have the Companies Act details, and a number of websites I've seen from startups that don't have the name of the company, the registration number, where registered on the site. Important to get that right. And also with websites, it looks good, and it can be important to have a privacy policy, particularly if the website's creating data, catching data. And also, if necessary, have some terms of use, particularly if there's any useful information put on the website to avoid, for example, spiders scraping the information from the site. And lastly, think very early about what IP rights you need. Andy mentioned, the balance between patents and whether to keep something a trade secret, but don't forget the importance of trademarks and domain names and getting those done and presenting your trademarks correctly. And finally, which is what the next few minutes is about, is the importance of getting contracts right. Next slide. So here's the innovation stage, and you've got your basic idea, the concept's proved, you're developing it. You're probably going to want to put that invention into a spin-out company or a startup. Spin-outs sort of coming out of universities. Startups tend to be more independent, quite often coming from a commercial background. When you're doing that, you need to work out when to transfer the IP. In that process, you have to identify who owns it. So just looking at universities, spin-outs, almost every university these days has a policy that indicates probably that the university owns any IP created by the academic researcher. They will also have policies about helping spin-outs with their first patent filings and so on. And these are contracts. They need to be read carefully and understood. we've had examples where academics have signed up to help from universities and found that the university has been exercising considerable control over how they run their business and want to develop their ideas. Anne mentioned the subsidy control scheme. This requires universities to demand some form of financial or other reward from their research. Their IP cannot be handed over to a spin-out without something in return. And mentioned the idea of parking it to some point in the future. That is generally, as Anne said, a bad idea, not least because it gives the university control over what you might be able to do with the IP further down the line when its value is beginning to be proven and can demand more from the spin out as a result. Ways to resolve that might be by giving the university a stake in the spin out early on, agreeing with the spin out at what point, agreeing with the university at what point the IP can be transferred to the spin out, or if the company has enough money to agree an upfront lump sum for the transfer, which represents the financial input from the university. Quite often, the universities are quite keen to get that because it helps with their financing. Anne and Andy also mentioned the importance of confidentiality. University knows the information. They need to be required to keep it confidential as well as the spin out. But there is the desire of the university to publish, and that needs to be controlled. And lastly, on ownership, universities generally want to keep hold of the IP and license it to the spin out, at least until the spin out has proven itself. And sometimes with some universities, a lot longer. And that's fine, but you need to be very careful about the terms of the license and what restrictions the university can place on the spin out. There could be restrictions relating to change of control, to sub-licensing. Both of these allow the university to come back at a later date and say, we'll give you consent to change control of your business or to sub-license it to a big pharma company or a big semiconductor company, but you're going to have to pay a sum of money for that, and that can restrict the ability to do deals. Next slide. Moving on to the development stage. Here, it's quite often that when you start talking to potential collaborators for R&D or commercial collaboration, an NDA is the first thing to be signed. Everybody thinks NDAs are fairly standard documents, but they're not. They are short, but they do need to be read and understood. They need to be it needs to be worked out exactly what the NDA is for, what the evaluation is for, and whether any IP will be created as part of the evaluation. Then there will be other agreements. I've listed some of them there. There could be consulting agreements where a company has decided to get, it's decided to augment its team, and they may do that by entering into consulting arrangements with third parties, including with PEOs, which are professional employment organizations. And it's very important to understand the contractual background to those arrangements to ensure that the IP created by the consultant gets to the spin out to where it should be. Material transfer agreements. Don't forget that if you're handing over materials, they need an NDA as well. And there's some specific clauses relating to the handover and getting the information back. Anne majored on the importance of ownership and background and foreground. Background typically in these contracts will remain owned by the party that brought it to the party, to the agreement. But what can it be used for? And can it be used for post-development, i.e. for exploitation? Foreground, who's going to own that? Anne spoke about joint ownership. that is generally a bad idea because it means different things to different people, and it means different things in different jurisdictions. So if you're going to agree joint ownership, you essentially have to agree all the parties' rights to use and exploit and sub-license that IP to avoid problems in the future. And don't forget the consequences of termination, the expiry of the development stage, who's got rights to do what. And lastly, as I mentioned, there is the importance of project governance and management. Next slide. This deals with investment and exit. I mentioned this because quite often during the course of the growth of a spin out or a startup, obviously investment is going to come in, and that can come from angels, VCs, from private equity, from trade partners, and these guys will want different things. Particularly the VCs, angels will want obviously some financial comeback. They want probably an early-ish exit if they can get it. Trade partners will want different things. They'll want to know the product works, and they want rights to the product. And it's important to consider who wants what and whether it matches your expectations, particularly relating to the control that VCs typically will want to exercise over the spin out. Lastly, just mentioning exit, that could be via trade buyers or via private equity, or an IPO. And in all these transactions, there will be some key issues arising, which the investors or the or a buyer on an exit will look at. They will want to carry out due diligence on the intellectual property, and they will be looking very closely at the chain of title ownership to use the key IPRs, the rights to use key IP, the rights to use the key IPRs. They'll be looking at the license terms. They'll be looking at whether the intellectual property is sufficient to run the business being offered, and they'll be looking at the validity of licenses in and licenses out, and also the risks of third-party rights causing problems with infringement. It's very important, as we will see, that in order to answer these questions, you have your contracts in place, can point to them, and have everything in good order. Last slide, or next slide. Exploitation stage. You have a product, it's up and running. There's going to be a series of key contracts that you will likely enter into. And these contracts are very important for the downstream operation of the business. So where there's collaboration or technology licenses, improvements, the question of intellectual property ownership needs to be thought about, similar to the foreground issues that we were talking earlier. Contracts need to deal with risk allocation. And this is typically dealt with by way of liability clauses limiting liability, by what the parties giving warranties and representations, for example, about the ownership of the IP. They might well give indemnities if there's third-party issues, third-party sues the company for intellectual property infringement, who's going to pay for that action. And don't forget, in the international arena, the importance of getting the jurisdiction right. Some countries have better and cheaper courts than others, and some have strong governance procedures. And don't forget the commercial terms such as pricing, quality, the importance of getting the specification right, because the warranty will be tied to quality control. Warranties will be tied to the specifications, and the importance of management. And lastly, don't forget about export control. I think the US have just issued an executive order relating to artificial intelligence, which allows some of that technology to be transferred to countries like the UK and some EU countries, but not other EU countries. So it's important to understand the export control ramifications of the products you're in. Last slide. So the key takeaways that I've listed is presentation, get your basics right, as I mentioned. It's a really good idea to paper transactions, get the contracts in place, get good contracts in place, speak to lawyers, don't be afraid to agree costs up front. Most lawyers will want to help, will want to get the business in, so don't be afraid about pushing us on costs. I shouldn't say that, of course, but I do. And lastly, get your ducks in a row. So if you're a startup, have a data room from the get-go, know where all your contracts are, have them in order, and make sure that you can produce those when the investors come along in good shape. So thank you very much.
Okay, great. Well, yeah, some really interesting points, very comprehensive, a lot of stuff for you to think about there. So thanks, Anne in particular, from Paragraph, and Mark for talking us through all of that. I'm getting a message on screen, Chris. Is that something you can see? The host has asked me to start my video.
It was just to start your video, Andy.
Right, I see. You mean here. Right, yes, I'm with you. Yeah, okay. IT test passed. Yes, good. Well, anyway, I hope you learned something from that. Before we move to questions, I just wanted to take 1 minute to mention EIP's new legal service, which is called Amplify. It's a strategic IP and legal advisory service targeted at semiconductor chip designers and deep tech electronics and photonics companies. Essentially, it kind of brings together what I do on the patent attorney side and what Mark does on the commercial contract side, kind of pooling our experience in IP strategy in this space and the expertise that Mark brings in from his commercial team. We can look at anything from IP strategy, development and optimization, drafting and negotiating commercial agreements for collaboration programs, as well as guidance on some of the things we talked about earlier, like know-how, trade secrets, patents, and how you get that balance right. So yes, if you'd like to hear more about that and you like what you've heard today, then please get in touch. That's all from me, Chris. Back to you.
Thank you very much to Andy, Mark, and Anne. So before we come to the Q&A section of today's broadcast, I just want to bring in Adam Wood, who is NMI Network Director, just for his reaction and perhaps observations on what's been presented to us today. Adam?
Sorry, just needed to unmute myself. I thought it was all very fascinating, to be honest. I've done very little work with legal contracts, IP, and the such in my previous role. However, I have had some discussions with Andy over the last year or so, and I had a little bit of knowledge about what they were trying to achieve within our sector. But the first thing that he highlighted today was the partnerships announced in this sector, and it happens almost every day. You see something new, and it just highlights the importance of making sure that you're protected from the get-go. And then when Anne was talking a little bit about the David and Goliath situation, I can sort of understand that as a Goliath. You know, they're going to be, and as a David, you're under pressure. And I understand that, but the Goliath is holding all of the power balance in that situation, which I sort of understand. But then coming on to the universities that you mentioned, and as well, I really had no idea about the joint sort of licensing that they seem to have. They seem to want to have anyway with commercial organisations. So all in all, I've learned a lot as well, and it's just been a very good listen.
All right, fantastic, Adam. Thank you very much for that. So let's get the Q&A section underway. I won't direct this particular question to any of the speakers today in particular, but if anybody feels, compelled to answer first, then please go ahead. So I've just been noting down during the broadcast, one of the points that was made during the session was that a company developing technology may not necessarily own the rights that they think that they own. Can anybody give an example of how that might happen and what the consequences could be?
Yeah, I could chip in there. I'm sure Anne's got examples of this as well. But one thing we've been working on recently was a company augmented its team with a couple of consultants. The consultants were provided by a company that they'd worked with in the past that did software development work, and there was an agreement whereby that company agreed to assign any IP that it owned arising out of the work of these consultants to the startup company. The startup company then further down the track was looking at getting some investment in and needed to show chain of title, plus the fact it wanted to file a patent in relation to an invention made where these two consultants were involved. And when we looked at we were told when we came in to look at it that don't worry, there's an agreement between us and this company whereby all the IP that these guys produce belongs to us. So there's no worries there. But when we actually looked into it in more detail, the position was an awfully lot more complicated. One of the consultants was an employee of subsidiary of the consultant company. The other one was provided to another subsidiary by a professional employment organization. So there were sort of a chain of agreements needed to come from the individual who produced the work and who, under the law of one of the countries where he was working, he owned all the IP, irrespective of whether he was an employee or not, unless there was a contract that said otherwise. And so you have to start at the consultant and work through all the chain of contracts to get to the right place. And for patent filings, you may need to short circuit that for the benefit of, for example, the USPTO, by being able to produce a one-page bit of paper from the inventor to the company who's making the filing saying, yeah, I agree, this company owns all the IP. And that needs to be drafted quite carefully because of the chain of title issues. Anne, sorry to talk.
Yeah, no, I completely agree. Chain of title is absolutely critical, and you can be certain. You mentioned, Mark, in your bit of the presentation about rounds of investment and M&A and things like that, and you can be absolutely certain that these things will be unearthed in the due diligence. So you have to be on it, especially when there's contractors, consultants, students, and so on. But the other type of contamination like that might come in is sometimes completely inadvertent. Sometimes it's misunderstanding. So I've had scientists say to me, "Oh, I've read this fantastic publication. We can do that, can't we? Because it's published. It's in the public domain for everyone to use." But what they don't realize is that just before that publication was put out, the people and the authors filed a patent. And so it's not certainly the case that what you see published in a journal is absolutely free to use. You would have to have, a license to the patent potentially. So there's that. There's then things like in software, open source software. So that gets built in, rather than reinvent the wheel, people will incorporate open source software. That's fine as long as you comply with the requirements of the open source license. So that would be another instance. And then other things would be things like, employees coming into your business from direct competitors and bringing with them an understanding of how it was done elsewhere. And you build that into your processes, and then inadvertently you're bringing in IP that you don't have the rights to use. So there's many, many, many ways that this can happen. You just have to be on the lookout.
Yeah, and on that last point, you see quite regularly, particularly with US organizations, where if you look at their employment contracts, there's obligations on them A, to warrant that they're not bringing any third-party IP with them, and B, if they are bringing any third-party IP with them, that it can be used by the company they're bringing it to. And if they can't, they have to list all the IP sometimes that they know about that they can't be used. And this is all to protect the company downstream from infringement actions from ex-employers.
And if I can just add to that, I mean, on the thinking of it in terms of inventions and patents, and the collaboration piece specifically, in the UK at least, when an inventor develops something, their employer becomes the owner of that invention, and therefore the owner of the patent. So when you're collaborating and you've got employees from two organizations working together and potentially developing ideas jointly, if nothing is done to manage that, then you may get this joint ownership situation, which is why you need your agreement to very carefully deal with that and specify who will take ownership, who will get licenses, and often it's based on subject matter, who is contributing, who's bringing primary expertise in different areas. But yeah, the point is, if you don't do anything, then it can become a bit of an ownership mess, and you might see something developed in the course of the collaboration that you think you'd be getting ownership of, but actually you're not. So, but this all needs to be dealt with up front.
All right, thank you to all three of you for that response. So questions coming in on Zoom chat. I'll go to the one from Edward first. I'll read these questions out in chronological order. Hello, thank you all for a very informative talk. I was wondering if you can repeat and/or elaborate on the main aspects of active management of IP on the ground. Thank you. That question's from Edward.
Thank you, Edward. I think it was me that kept talking on about active management of IP on the ground. Yeah, by that I mean that it's tempting. You get involved in the collaboration agreement. I as head of IP at Paragraph, get involved in that contract stage, and then you might put that agreement in the drawer and never really get involved in it again, and not actually get involved in the project. So what I'm suggesting is you do get involved in the project. You make yourself visible. You go and find out what's actually happening. Are the project outcomes being fulfilled? Have we invented stuff? Have they invented stuff? Are we dealing with it correctly? Have the objectives changed? You have to just keep up to date. And it was also like the scenario I was talking about with this terrible David and Goliath scenario, where David got stuck and Goliath basically patented some of its IP. And as Mark was saying in his example, there was lots of things that David could have done. It could have really been careful to share only what was absolutely necessary with the other partner. There's so much stuff that you need to just keep reminding people and keep sticking your nose in and talk to the project teams and make sure things are being handled correctly. So yeah, don't just sign an agreement, forget all about it.
Yeah, I'd add to that, and Andy can probably give more detail, but just thinking about the patent process, there's a whole host of questions that's going to arise from the time you first file, about where else you're going to file, who's going to pay for it, what happens if you lose interest in a particular technology, whether you're going to file divisionals and continuations and so on. And if you're in a collaboration arrangement, the parties will want to know what's going on there, and they may or they may not want to have input into those decisions. And particularly difficult can be where a company, and this happens quite a lot actually, decides that a particular patent is actually no longer of interest to it because the technology's moved on and the patent doesn't read on what the technology is anymore. And who's going to, who cares about that patent now and what's going to happen to it? And that can lead to some quite difficult discussions.
Yeah, absolutely. I think what I would add to that is that having an active IP management strategy and process is not about deciding to patent everything. It's not about saying that you need to be taking active decisions to file patents, which we all know are expensive to invest in. But it's about having a strategy where you're very clear about the ideas that have been generated in your business, the value they bring to your business, how they fit in with your business strategy, how they fit in with any collaborations that you're making, so that you can make decisions very early in the process about what you're going to keep secret, what you're going to share in your David and Goliath relationship, where you might need to file patents strategically to protect yourself, where you can get away with keeping things, you know, the crown jewels, secret and locked away so that nobody can see them. So it's all about just having a strategy, having a plan, and making sure it's clear. And because ultimately down the line, you know, other people, you know, investors, for example, are going to want to know that you've been diligent in your approach to management of this, and that you're not making reactive decisions because something's gone wrong.
Okay, thanks for that, guys, and thanks for the question. I think that was from Edward, wasn't it? Next up, I hope I'm pronouncing this name correct, Luntu. Some studies are pointing to universities generating more revenue from soft IP licenses, in brackets copyright, NDA, trade secrets, over patenting licenses. Forgive me. Is this true for the semiconductor sector as well? Are the best profit-generating IP assets in semiconductors only patents? That's from Luntu.
Okay, I'm happy to take this one initially. I'm not familiar with the particular study you're referring to, but I think the thing to bear in mind with semiconductors and electronics is we're generally talking about hardware. We're probably talking about products that you're going to sell and put on the market, even if you're selling to a tier one or an OEM. And that is a world that is generally far more dominated by patents as a kind of asset class within IP than it might be, for example, in the software world, you know, and software businesses. So you definitely need to think very carefully if you're putting a product onto the market where there are larger players who have active patent strategies, that you're playing in the same way and with the same tools, and you know, and that sort of thing. But it's not to say that patents are the only class. We talked a bit about trade secrets. Certainly, when it comes to semiconductor processes, if your innovation is more about the process of how you make something, then often that's not discoverable in the end product, and it might be something that can be kept as a trade secret. And it's the trade secrets and the know-how that you might, for example, ultimately be licensing out to, you know, a fab or a manufacturer. So there's certainly no easy or kind of unilateral answer to saying that one or the other is necessarily better, but those are some of the sorts of things that you're going to be considering when you think about semiconductor-based technology.
Yeah, I think I'd add to that. I completely agree that there are many different types of IP. As an IP manager, I have to very holistically look at all types of IP. So it's not just patents, and particularly for Paragraph's business, we're making graphene electronic devices, and a big part of our IP is trade secret, because as Andy was just saying, not every type of invention is suitable for patenting. How would you detect infringement of something? How could you prove someone else was doing the same thing? So we absolutely choose to keep stuff trade secret. I think if you look at TSMC, you know, very, very famous, huge semiconductor manufacturer, they actually have really useful and interesting publications talking about how they protect their trade secrets, because it's hugely valuable to them. And obviously, you know, they're setting up TSMC in the US now as well. And the practical implications of transferring that knowledge from Taiwan into the US is all about that trade secret knowledge. It's hugely valuable. But in Luntu's question there, he talks about the university and trade secrets. In my experience, and it's very difficult to work on trade secret work in collaboration with university. And that goes back to what I was saying in my talk about just the practicalities of universities. They're there to teach and disseminate information into the world. And it's very, very counterproductive for them to be bound to something where they can never teach something, never publish it, because that's what you have to say when you're creating a trade secret. You must never share this. So that just doesn't really work very well. So so for universities, which was the point of the question, I would be surprised if it's trade secrets. But absolutely in the space in AI, which is not a space I know terribly a lot about, but that's obviously massive area, as we know from the news out of the US just yesterday. So profit generating IP from copyright, absolutely, and database rights and all of that too, will be huge.
Christopher, do I have time to just add a couple of comments?
Of course you do.
Yeah. So I'm just approaching it from the point of view, you know, maybe an investor looking at a startup. I think Anne was talking about trade secrets in relation to a very large company. I think the larger a company gets, perhaps the more valuable trade secrets become because of the mechanisms for keeping things secret. At an early stage, I think, you know, one of the big problems is with trade secrets is that it's only as good, they're only as good as so long as they're secret. And you know, I think Anne mentioned the issues with reverse engineering during her section. As soon as a product's out there and it can be reverse engineered, then the confidentiality and trade secrets become less valuable, and that's a concern to investors. Incidentally, you can put contractual restrictions on reverse engineering in contracts and collaboration arrangements, providing they're not prohibited by law, as they are a bit in relation to copyright law. But that will only protect you for so long as that collaboration continues, because, as I said, as soon as the product's out there, it can be undone. Copyright is a very valuable right because it arises automatically. You don't have to do anything. The problem with enforcing copyright is you've got to prove copying. Again, you know, once a third party, if it's determined to create something that's very similar to a product that somebody's got copyright in, they can go in and they can take the idea and they can rewrite the code so that it's not actually copying. And there's quite a lot of litigation, and it's very expensive and long-lasting litigation trying to prove infringement of particularly software code is a tricky area. And that's one of the reasons why investors like patents, because, you know, they are a solid piece of property. They have been peer reviewed, if you like, by patent offices, and they've got past a prosecution process, and so that is something that investors can focus on and think about value. And certainly in the electronics industry, you know, when you have technical standards being created, having patents is extremely valuable to participating in that whole standards process. So,
okay, thank you very much for that. Do we have time for one more question? I think we may as well. This was actually directed at Anne. Anne, in your section, you mentioned that you need to consider who owns a rising IP and what exploitation rights the other gets to it. Instead, you could jointly own the IP. What are the implications of doing that, Anne? Oh, you're on mute.
There we go. Yeah, joint IP. Mark actually touched a lot of this. It's not great for commercial companies, and that really, in a nutshell, is because the law is different in different countries about what you can and can't do with joint IP with or without the consent of the other party. And it's also different for different types of IP. So the law for patents in one country can be subtly different to the law for copyright, for example. So it gets immensely complicated if you're silent in the contract on how that's all going to be handled. It's also really a nightmare to administer. So if you've got joint owned IP and you're trying to take decisions during prosecution about how claims might be amended, and you need to talk to the other party, you're going to have completely different views on how claims should be amended for the advantage or disadvantage of one or the other. So it's just a pain in the neck. It's difficult to get the costs paid for. You might agree you're going to share the cost, but every invoice that comes in, you're going to have to go and get the other party to pay their share. It's a nightmare. So there's really good legal reasons and also practical reasons. And the third reason is absolutely every time you go through a round of funding or M&A, it's going to come out. You're going to have to, the other parties, the investors are going to say, what patents or IP have you got that's jointly owned? And in an extreme scenario where I've been through an M&A, the other party who was interested in acquiring the business said, we don't want you to have any joint IP, get it sorted out. We don't care if you end up owning it entirely or licensing it, but just make sure it's not joint. So it can be quite extreme. So I prefer to avoid joint IP wherever possible.
Yeah, just
thank you for that.
Yeah,
go on, Mark.
Yeah,
go on.
Just to add to Anne's point, just in terms of exploitation, if you've got joint owners, does that mean you've got a competitor and a natural competitor straight in the marketplace, or are you having to divide up the market between different fields of use, which can cause problems because invariably they overlap?
Yeah, absolutely. And Andy will tell you all about the unitary patent court and unitary patent rights and how it's really important in there as well. There's so many reasons why it's just not a good idea.
Yeah, and what happens if you want to apply for a patent in, I don't know, China, but the other people don't, and who's going to pay for it, which Anne mentioned as well. Yeah.
Well, and I think the point to take away from all of that is that it can all be sorted out if it is sorted out, because you've got people who know what they're talking about at the beginning. These things tend to arise when people don't think about it. And that might just be because they've never come across it before. And then you get all of these sorts of situations. But typically you can have a collaboration where it determines who's going to own what, typically based on subject matter, with licenses back to the other side. So you still get rights to use the tech, you just don't have a joint ownership situation. So.
And the upshot of all of that is that people need to be talking to EIP about such matters. I'm going to circle back to that point in just a couple of moments, but just before we wrap things up, Adam, I want to bring you back in because we have got the 2025 NMI conference happening in Glasgow. Headline sponsor will be Zeiss, and it's on the 26th of March. Adam, what can we expect?
Thanks, Chris. So the theme really this year is to discuss the next decade within semiconductors, but also the key drivers within the next 10 years, whether they be societal or technology based, and how semiconductor technologies are going to come into play, essential basically to make these drivers work. So it's setting up to be another stellar event. So please do register. You can find the link on our website to do so. I would very much urge you to be a part of this conference. Thank you.
Nice one. Specifically, nmi.org.uk/conference. So, Andrew, Mark, and Anne, let's say that you're an NMI member and you've been sat watching this broadcast today and you want to know more about the topics that have been covered. What should I do?
Well, it depends who you want to know more from. If you want to know more from EIP, I think we had our contact details on the last slide. You can contact me or Mark directly at our personal email addresses, or connect with us on LinkedIn, follow us on the usual social media places, or go to our website. If you like what Anne's had to say, I'm sure she wouldn't mind you getting in touch. I think we shared her email address, and I guess, Anne, you're also on LinkedIn, etc.
Yep, absolutely. Very happy to talk to people outside, no problem.
And it's eip.com for your website, isn't it? And paragraph.com for Anne as well. That brings us to the end of today's broadcast, I'm sorry to say, but thank you for everybody that watched today. We've had a very healthy audience, and thank you for the questions that were put to us on the Zoom chat. This broadcast today has been recorded. So if you'd like to watch it all again, or you can just circle back on certain bits that you would like to view again, then look out for that coming on the NMI website imminently. But in the meantime, my thanks to my NMI colleague, NMI Network Director Adam Wood. We also had Anne from Paragraph and Andy and Mark from EIP. Thank you very much for watching, and we'll see you next time for another NMI webinar. Thank you.